The second part of our program dovetails perfectly with the first part. We've heard some extremely stimulating remarks in the context of mainland China. And now we can hear from Taiwan's experience. And what can we learn from that? What can China learn from that that might be useful? And is there more for Taiwan to learn from the mainland? I think we have 5 excellent speakers, highly informed from different perspectives. And I think you'll find it interesting, and I hope you'll take advantage of the opportunity to make some comments or ask questions. Our first speaker is Margaret Lewis. Maggie Lewis is a 2006 or 3, God.
But you can make me younger.
2003 JD graduate of NYU Law School. I should remember that. She wrote a wonderful paper that was published in the NYU Law Review, I think, about the April 1st, 2001 incident between a U.S. reconnaissance plane and a Chinese fighter and the international and domestic law implications. Maggie and I have just finished a book about Taiwan's equivalent of the much talked about re-education through labor that we just discussed. When I first went to Taiwan in the early 60s, I immediately noted the similarities between what was then called Guanxun and Lao Jiao. And our book really goes about the life and death of that important sanction. So Maggie, who teaches now at Seton Hall Law School and is an associate member, we're proud to say, of our U.S. Asia Law Institute, which she helped start when she was here following her clerkship and her earlier graduation. Maggie, Qing Zhao.
Thank you, Jerry. It's always a pleasure to be back. And actually, thinking back when the Institute started, it was Jerry and Yuping, who's here, and me, and various other people would float in, but it's wonderful to see how large it's gotten. And Ira Belkin asked the other day if anyone knew where the logo came from, and I said, yes, I plucked that off the internet because I thought a lotus blossom looked like the NYU torch. So that's held on. But I'm sorry I missed the first panel. I was teaching 1Ls about accomplice liability, and but I am delighted to be here now, and I'm particularly sorry I missed the conversation about re-education through labor, because that directly relates to what I'm going to be talking. I plan to keep my remarks relatively brief because I know we have a lot of knowledgeable people in the audience, and I much rather leave time for Q&A so we can focus on what also you want to discuss. But what I want to do in my time is give a little background on Taiwan's legal system, and then talk about this past, and I can say now it's in the past, system for dealing with liumang, or hooligans, as it's often translated into English, and then finally say a little bit about what Taiwan's experience might mean or how it might be helpful as we look towards the mainland and the future of re-education through labor. So first, with respect to background on Taiwan's legal system, I know some people here are very familiar with Taiwan, but I've also learned that just because people are familiar with mainland China, it doesn't mean they know anything about Taiwan. And it's got a very different legal system and very different history. It's also a lovely place to visit, and I'm sad I'm not going this summer because I love the mangoes in Taiwan, and I heartily encourage you, if you have a chance, to go, particularly in the summer. But so Taiwan, you probably all know that in 1949, Chiang Kai-shek's nationalist government fled the mainland, set up camp in Taiwan. And when we look back now at the over 60 years since that occurred, the first 40 or so were not the free China that Taiwan sold itself on the international stage. In fact, it was a very harsh authoritarian government in place, and military law, you had martial law up until 1987. So for the majority of Taiwan's history under, as the Republic of China on Taiwan, it has not been the free China that at least vis-a-vis, people would say, of Red China in early on in the U.S.-China relations. But in the 1980s, you saw a shift, and Chiang Kai-shek had passed away, and his son, Jiang Jingguo, who early in his career was certainly not a warm, fuzzy human rights activist, very involved in secret police, not someone who people would look to as the shining hope to bring in democracy, but he saw changes occurring, and he helped to usher in a change from single-party authoritarian rule under martial law to what is now today really a vibrant two-party democracy. And I think part of the hope as we look to the new leadership every 10 years now on the mainland is there the Jiang Jingguo? People always say, is there the Gorbachev? But for those of us who study Taiwan, I think we're more wondering, is there a Jiang Jingguo in the midst who's going to start transitioning? But during the time of martial law, you had what was called the temporary provisions effective during the period of communist rebellion. They were not temporary, they were in for many, many years, and it gave the government the ability to lock up basically whoever they wanted. There was not much in the way of judicial independence. But following the end of martial law, you saw a diminishing of police powers and gradually handing over from the military to civilian rule, and particularly this was important with how prisons were run, and for these liaomang with respect to who was in charge of their incarceration. And then as Taiwan got through the initial time after martial law was ended, and then there got this more, I think, nuanced and interesting discussion about what should be the future of Taiwan's legal system. And particularly of interest to me, and this project that Jerry and I have been working on, is the future of Taiwan's criminal justice system. And in 1999, there was a pivotal judicial reform conference. And at this conference, some macro decisions were made about how the criminal justice system would be structured going forward. And there was a major shift that came out of that, going towards more of an adversarial US-style criminal justice system. The way that it was phrased was a reformed adversarial system. Prior to the 1999 reforms, Taiwan's criminal justice system much more closely resembled continental inquisitorial style criminal justice, a focus on a prosecutor-led and investigative stage, a handing over of the dossier to the courts, and then the court proceedings themselves were largely judge-dominated, the judge asking a lot of questions, without a lot of role for the prosecutor and the defense lawyer at the trial itself. In fact, the prosecutor who would appear in court might not know much of anything about the case because it was a fairly perfunctory appearance. And then when these reforms came in, the goal was to make it so there was at least a more trial-centric experience, more role for particularly the defense. If you go to Taiwan today, you're welcome to go to the courts, which I find fun. I don't get to do that in the mainland just for the fun of it. And you can go in and watch the trials taking place. And it's going to look similar to, although certainly not just like a more US type system. Now there have been challenges in implementing these reforms, and I'll leave that to my co-panelists. But with that background of sort of the macro view, what is this Taiwan equivalent to re-education through labor? It's a non-criminal, or as I like to think of it, quasi-criminal, because if it sounds like a duck and it looks like a duck, I mean, the system for dealing with liaomang looked a lot more like a criminal system than it did, I would think, an administrative system because of the harshness, particularly of the punishments. And this word liaomang is usually translated as a hooligan. Doesn't really capture it. It's someone, it could be some gang activity, sometimes gambling. My favorite was people who eat and drink without paying, people who demand protection money, So any kind of like it's kind of a bad egg you wouldn't want to run in on the street and is involved in sort of usually relatively low-lying crimes, but it could also be more of what we think of as organized crime activities. And when the first regulations dealing with liaomang came into place, Taiwan did not have a specialized organized crime law to deal with that aspect of criminal behavior. They do now. Now, these regulations to deal with liaomang developed during the martial law period, and then when the shift occurred to civilian control, they hung on. And there was a transition, and in 1992, when the facilities where these liumang were held was shifted to away from the military, we got this new 1992 Act for eliminating liumang. And it looked largely like what was in place before that time. And there was a two-track system put into place. So you had some of these liumang who were considered relatively low level, and they would just be treated as warned liumang. They would be subject to a probation-like system where they would have to check in with the police every so often. They were generally monitored to see how they were doing, but their day-to-day activities, they were free out in the street. And then the more serious liumang were the ones who would be tracked through a court proceeding and could end up to 3 years in a it was called, it was a re-education sort of type institute. It was they call them institutes instead of prisons, but these institutes were on the same grounds as prisons, and we visited them, and they looked exactly the same to us, but they were called institutes. But it was a place where the liumang would be put behind bars. And even with these changes after martial law, the major changes were occurring to the criminal justice system, and the system that was dealing with these liumang wasn't changing that much. You still had a largely police-dominated process. You still had a heavy reliance on secret witnesses. It was very hard to find out sometimes who even were the witnesses against you. There was a strong inquisitorial bent. Prosecutors were not involved in the courtroom process. Instead, there was a special public security tribunal, which was a tribunal within the criminal courts that dealt specifically with these cases. And there were significant hurdles to mount a defense. It was really hard for a defense lawyer in the few cases where someone hired a defense lawyer for them to get access to meaningful information that they could mount a defense. So with all this going on, there was a lot of, a number of really reform-minded judges, law professors, other people in Taiwan who questioned the validity and the constitutionality of having this track maintained for liumang. And that got Taiwan's constitutional court in the mix. Taiwan has a court that is dedicated to dealing with constitutional issues. If you're familiar with the German system, it has a number of similarities with that. So the Constitutional Court, known as the Council of Grand Justices, issued 3 interpretations, the first one in 1995, the second in 2001, and the third in 2008. And in these interpretations, they gradually struck down aspects of the Liumang Act, focusing on particularly the use of secret witnesses and constitutional violations with that, the police ability to make people appear without any judicial procedures, concerns about double punishment because people could be going through the criminal system concurrently with the liumang system, and depending on how fast one or the other played out, you could end up with a harsher punishment because of the dual track, even though the same acts were being punished. And the final interpretation in 2008, which was actually raised by a couple judges who were hearing these kinds of cases, and they said, wait a minute here, we're hearing these cases, we think there's a constitutional problem, got kicked up to the Council of Grand Justices. The Council of Grand Justices did not strike down the act in its entirety. Instead, it kept drilling holes and saying, well, that provision's unconstitutional and that provision's unconstitutional. And then it was left to the legislature to decide whether it was going to fix the law so it was constitutional or just get rid of it entirely. And about this same time, this is 2008, if you know about Taiwan's political system, Ma Ying-jeou had just come into being president. And the executive branch went ahead and said, we actually recommend its abolition. And so you had the executive branch recommending abolition of this act. You had the judiciary significantly questioning the validity of the act. And the legislature finally went, we're going to repeal it. And so it's really amazing, all 3 branches coming together and saying this is antiquated, we're getting rid of this, this whole process. We're 4 years out now from when that happened, and from all accounts, I've talked to people, they don't have any, can't say for sure, but it doesn't seem like there's been a deterioration in social order in Taiwan for lack of the Liumang Act. Any sort of Chicken Little, the sky is falling if we don't have this tool for police to use, has not come to pass, at least thus far, and I doubt it would now that we're that far out. And the regular criminal justice system seems to be fine at dealing with infractions that were formally dealt with under this act. So that's the story of sort of Taiwan's transformation with respect to the Liumang Act. And so how might this experience be relevant or interesting or at all helpful to what's going on across the strait with re-education through labor? As Jerry mentioned, there's some immediate obvious parallels in the length of the punishment. 3 years for re-education through labor, 3 years if you were a Liuomong who was incarcerated. Police-dominated process. The Taiwan experience at first had no judicial involvement, which is like the re-education through labor, except for on the back end, theoretically, you can do your administrative review, though that seldom occurs. But in Taiwan, they started to get a little bit of judicial process there. The one thing we've questioned is, well, maybe this having two categories is one way to at least start ameliorating re-education through labor. Perhaps you could have sort of the warned Liuomong, the warned people who don't go to the re-education through labor camps, but have some form more of a probation system, and then have only a smaller category going to actually spend time in the camps. The other big issue is really about judicial review. And for the Taiwan experience, this started with a different, but still a judicial review going within these tribunals, and now there is no special tribunal, it's just the criminal process. I'm hesitant to say just because you add judicial review, and I understand that Frank Upham raised the question of how much process helps the system. So I'm hesitant to say just because you give more process in the mainland, you're going to get better outcomes. What you need is you need judges who are willing to stand up to the police and sincerely question why the police thinks this person should be locked up. If it's merely a rubber stamp procedure to, for example, meet the needs of the International Covenant on Civil and Political Rights, which you'll hear more about, and say, hey, look, we have process. It's not just the police locking people up. That's not real process. And that's kind of how do we get judges in the mainland who might, and prosecutors as well, who might not be as influenced by what the police say. That's going to be a long-term process. There have been some glimmers of hope that at least with respect to the political legal committees, which are party organizations which are so powerful in particularly sensitive cases, that maybe at least the local public security people are not dominating those committees as much as they used to. Still influential, but maybe not quite as much. So perhaps we're going to see some room to have the judiciary taking a little bit more of a role and looking what would happen if we gave a hard look to whether these people should be locked up, even if you kept re-education through labor. And I also think it bears noting that there's a big difference between Taiwan and the mainland with respect to criminal justice more generally. All criminal justice systems are flawed. I teach criminal procedure as well as substantive criminal law, and I teach the bail to jail, the adjudication and the prosecution and adjudication phase. And one of the first cases we do is Gideon, right to counsel. And I tell my students, if you want to feel really good about our criminal justice system, just drop the class now. Go home with Gideon, think everyone gets a lawyer who's indigent, and it's fabulous. Watch the Hallmark movie about Gideon representing himself. But we're 50 years out from Gideon, and we haven't done a fabulous job of implementing it. That said, like Taiwan has not done necessarily a fabulous job of changing their criminal justice system, but they've done a lot more than the mainland has done. And if I had to choose not knowing anything more than I would be a defendant in Taiwan or the mainland, I would choose Taiwan, knowing nothing more about what the charges were. So with Taiwan, as the criminal justice system embraced more sort of defendant or human rights friendly reforms, the Liuomong system looked increasingly out of step with that. And in the mainland, you've had major changes, especially in the revised criminal procedure law, but there's still a lot of challenges to even mounting a defense. So the difference perhaps between the regular route for criminal justice in the mainland and re-education through labor might not be as stark as it looks like on paper. And in fact, some people had said, I don't know if this came up in the first panel, perhaps people would be worse off if re-education through labor was abolished because then they would all be tracked into the formal criminal justice system. I'm not convinced that they'd be worse off. First, that's assuming that cases that are brought as re-education through labor cases would all be brought as criminal cases. Maybe not. And secondly, I don't know necessarily would the sentences be 3 years, as they can be or more, as they are with re-education through labor. But I do think it bears looking at how more judicial procedure might actually be meaningful procedure. And more importantly, I think it's really helpful just to question the U.S. experience is so removed from what's going on in mainland China. And oftentimes when we're there and for conferences, and I've been a number of times with Jerry and the Institute, people say, well, you don't understand our guoqing, you don't understand our country's conditions or our cultural conditions. Well, Taiwan, I mean, they're Chinese too. And so I think having the Taiwanese and the mainland jurists have better communication could at least stimulate some more creative thinking about re-education through labor and what the future might be. The mainland does not have a constitutional court. And at most, I think people are hoping perhaps a constitutional committee within the National People's Congress maybe could happen, but even that is a long shot. But not having a constitutional court to help push forward reforms makes us wonder, where is that continuing push for reforming re-education through labor going to come from? So as Xi Jinping and his cohorts are taking the helm, the hope is that maybe they'll realize that re-education through labor is increasingly out of date and not meeting the ideals that they're setting forth in the new criminal procedure law. And I also think that I'm hoping as cross-strait relations are at a relatively warm time that perhaps they'll be more open to having more input and at least conversations across the strait to think a little bit more creatively about Taiwan's experience, not only with respect to Liumang, but more generally how that might be helpful going forward. So with that, I'll hand it off.
Well, I'm delighted with that presentation. I hope by summer you'll see the book, and I'm not sure when the movie will appear, but we're casting now. I think it's best in view of the integrated topics here that we postpone the discussion and questions a bit. And before introducing our two speakers, I just want to say one or two things. Liumang is a term that's frequently used for people who get re-education through labor. It's one of the classic vague terms on the mainland. Second, the role of the Constitutional Court is very important in Taiwan, as Maggie said. It used to be a running dog of the Chiang Kai-shek dictatorship. It was an institution, but it didn't play any real role. And then it was transformed over time into playing a major role. Some people think too big a role in a democratic society. And finally, in the last part of our book, while we praise President Ma, as Maggie rightly did, for leading the abolition of this Taiwan special sanction, we also criticize him for making too little propaganda of it. This is a very major achievement of great significance to the mainland as well as Taiwan and countries other than Taiwan and the mainland. And I just think Chiang Kai-shek used to be a master of propaganda, and here they really have a product to sell. This accomplishment is very significant. I think they should make more of it, but we'll talk in due course about what Taiwan should be making of its human rights accomplishments. Now we're going to hear from two experts on Taiwan justice, Prosecutor Liu Shiguo and Court Judge Lu Yuren. These are experts sent by the Ministry of Justice in the first instance, and the Judicial Department of Taiwan in the second. And every year we get experts like this, and these two are unusually active and helpful, and I'm so happy we can hear from them. And who's going to lead off? Are you going to lead off, Judge Liu? Go ahead, please.
Thank you, Professor, and thanks for the U.S. Asian Law Institution invited us to make the presentation. First, I will be very glad to hear that just Professor Maggie said she will willing to be a defendant in Taiwan, but I hope that will not happen. And I'm going to introduce some reforms and some problems in Taiwan's criminal justice. Just like the professor has mentioned about, in 1999, we have a National Judicial Reform Meeting, which was during that time, which was happening some serious crime cases, and criticized the public media as criticizing about the judicial justice about our country. So the meeting, they have find something interesting and some make some conclusions, such as a balanced relationship between the judge, prosecutor, and the attorney. That means in our old system, that the judge lead the proceeding in the criminal trial procedure, and the attorney that makes some role in that procedure. And the other thing is the heavy burden of the entire criminal justice branch. That means the increasing number of complicated cases and the docket load. So in 2003, we enacted some reform. That's the reform of the advisory system in criminal trial system. We used to be the inquisitorial system, and we make a reform advisory system. The reformed advisory system, that means we just take a part of advisory system spirit and some ruling, some regulations, but not adopt it all of the part. So we still have some shadows of in the inquisitorial system. In that, during that period of reform, we make some principles, such as clarifying the presumption of innocence and enhancing the prosecutor's burden of proof, enacting the cross-examination rules, and also we take the hearsay rules and admitted by the United States. And also we enhancing the power of the party defense attorney for investigation of the evidence. That means we gave the power for the lawyers to asking the court to making the investigation of the evidence. And the other part, such as decreasing the burden of the case load, we expanding the deferred prosecution and the simple file trial procedure, summary procedure. And also we have some collegiate branch system, which is used in the minimized punishment of imprisonment for not less than 3 years. This is a reflect to some criticism that says that because we adopted by the European system, so we just passed the judicial exam. And all the judges who pass the judicial exam are be criticized they are too young, lack of experience. So we use this kind of system with the three judges that will combine each other's experience and making a good judgment. But after this kind of reform, we still have some problem. That is, the first part is we have some confusing between the judicial branch and the prosecutor branch functions, and should the judge be more neutralized to making the judgment during the case. And the other thing is the struggle between the inquisitorial system and the advisory system, because we combine two systems together. So, for example, we have the cross examinations for the trial, but also we have the judge can ask the questions for the defendant by his duty, by his obligation, something like that. So it's maybe a conflict between each other. And to respond to this kind of criticism, in 2012, the Judicial Yuan, they also organized some organization to, that's called the Criminal Procedure Reform Evaluation Committee. They have some discussion about how the problem we are facing with, such as the indictment with the evidence doctrine makes some of the prosecutors still hope the court investigate the evidence ex officio. And also the defense attorney's function and the defendant quality. Only 12% to 50% criminal cases with a defense attorney during 2000 years to 2010. And to enhance the equality between the defense and the prosecutor. I think the first part and the second part are, the first part is traditionally that we take the European system that makes, we have, when the case has been indicted to the court, they also send the whole evidence to the court. So as a judge, we have to find out is there still any evidence which is benefit or not benefit to the defendant. So that makes the prosecutor will rely on the court for this kind of defendant findings. This has been very criticized by the bar associations in the Taiwan society. And also the second part is the attorney's function under the defense of cruelty. I think this might be a little related to the Gilson's case or the recent U.S. Supreme Court cases decision about how they provide their legal service or legal opinion in the court. As I said, most of the time the lawyer will rely on the court to finding the truth. And the third part is the definition of the purpose of maintaining justice, that the court should investigate the evidence ex officio in Articles 163, Section 2. This is enacted in our criminal procedure law. This caused a lot of discussion. That prosecutor thought that the judge have an obligation to make a further investigation of the evidence due to this article regulations. But just recently, just last year, our Supreme Court make a new decision. They say that, well, the meaning of the maintaining the justice, that means the court only can find the evidence which is benefit to the defendant. So we have no obligation to help the prosecutor to finding the evidence. But this is increasing a large argument, especially for the prosecutor. They all disagree with these kind of decisions. And also, the fourth part is the failure of a reforming of an appeal court procedure. In 2003, in 1999 and 2003, the conclusion of that meeting, they say that we have to make the fact finding only on the district court. But there was some opposite opinions, so the reforming of an appeal of a court was still failure. They're still finding the fact that they have to cross-examination for the witness. So that wastes a lot of time and a lot of judicial resource. The fifth part is the lack of participation with the attorney in the summary trial procedure or the deferred prosecution. Because we think that the summary trial procedure, we want that more speedily, but also we need help for the attorney who provided a good legal opinion to the defendant to help them to select the procedure which fit to them. So we think this is also the important part which we are going to encourage that to increase the lawyer to participate in this part. And also, the conclusion has that committee also have found a problem that the usage of a deferred prosecution and not to prosecute expressor in criminal cases are only 60% to 20% between 2004 and 2011. That means nearly 80% cases was indicted to the court from the prosecutor, and from them there are nearly 58 to 46% cases were using the cross-examination procedures. So I remember that in that period, there's a judge mentioned about there were less trial cases in the American system. I very admire that because we took a lot of time in the court for during the cross-examinations. So comparing to the U.S. plea bargaining systems, I heard that nearly 95% cases was during the plea bargaining. So is this the direction should we take to reform our judicial system? But according to Professor Uphan speaking, I thought there will be some problems still inside the plea bargaining systems. The suggestion of that committee, that the main part is the balance of accurate rate and efficiency. They have some suggestion. Now, the first part is the divided criminal procedure reform. That means in misdemeanor cases and with the defendant confess the crime, such as a minimum punishment of the imprisonment less than 3 years, or the minor crime with minimum punishment of imprisonment less than 5 years. They say that they be using the special procedures such as plea bargaining, deferred prosecution, expected not to prosecute, simplified trial procedure, or summary procedure. And the other part that said, if the defendant arguing the case should use the normal trial procedure, no matter the case is misdemeanor or minor crime. And the last part is for the felony cases, no matter the defendant arguing or not, all the trials should use the normal procedures. That means that, and also they say that they request the judge participation in special procedure to improve the lack of attorney. That take the European system thought that the judge should more participating in the criminal trial procedure to be supervision of the decision from the prosecutor, something like that. And to help those people who don't have the attorneys. That's the traditional roles of the judge in the European system. Also, providing a more discretion power for the prosecutor in the special procedure. The purpose to doing this is trying to decrease in the caseload, which we can focus on the heavy cases, or the cases which defendants are very arguable, and make for speedy in the trial case. The fourth part, I'm going to introduce that the latest reform in the criminal procedure law. Just in 2013, in July 23rd, we enacting a new law with Article 31, Section 4. That's an amendment, not enacting a new law. That's an amendment law. That means the defendant or the suspect, because of a mental retardation, cannot be entirely of a statement or the operations in the investigation without legal assistance. Prosecutor, judicial police officer, or the judicial police shall notify the legal aid agencies established by law to assign a lawyer present for his defense. I think this is the expanding of the right to counsel in Taiwan, because this is the first time, except to the mental illness people, we have also gave the Aborigines people the right to assign a counsel in the interrogation procedures. And also we have legal aid associations. They have some programs. They also will provide who complete the felony cases. They will help them to make a presentation in the first interrogation in the police station. And the most important part, we also increasing the passing rate of the bar exam. About during 15 or 20 years ago, the passing rate is only 5 or 6% of the bar exam. And recently, they're just increasing. The increasing rate now it goes to the 10%. I know it's not compared to the American system, it's quite low, but they are trying hard to provide more lawyers into this market. And also, we have a draft reform of the judiciary trial procedure law. I think this is just like a lay judge system, the same as Korea and the same as Korea and Japan's reform, but they are quite different. Prosecutor law will introduce part of this. And also, because we want to make the whole procedure more transparency and to make the people to get involved with the trial procedure, to let them know the whole information. By the way, I just have to make a speaking that I know that the dramas, the eviction of a drama is very powerful. Our former constitutional judge has criticized for that, which is called Bao Qingtian in the Song Dynasty. It's a government officer who has exclusive power and the administrative power and the judicial power and allow torturing. You know, people in Taiwan still believe this kind of judicial system was greater than our which we are adopting now, because they say they can find in the truth. And also I have to mention about the LA law. When I was in college, I was so that, and the people in Taiwan also admire a lot for that. So every time we facing a big cases, there were two different sides of voice for the public media. Some people say you should finding the truth. Some people say you should protecting the human right. So this is a problem we are facing too. And also in 2011, we acted the Judge Act, which emphasizing about the judicial ethic issues and the supervision of a judge's evaluation system. This is also included the prosecutors. But this is also increasing a problem, not how the evaluation of the judge and the relationship between the protection of the independency of a judicial branch. Because I think the independency of the judge is very important in the criminal, in whole society, especially to the criminal justice. The most reform not only not only proposed by the bar associations, just like the professor has mentioned, that in the judge groups there are internal reflection for ourselves. So they are also proposing many reforms of that. So in nowadays, the judges in Taiwan are not hesitate to apply for the unconstitutional issues to the constitutional court. So I think this is a much good progress, and I think that might be the future of the China. They can make to consider this part. And also, we have a lot of constitutional court decision and the Supreme Court decision, especially in evidence rules, to making a progress and to improve our criminal justice. And there is some proposal about modified indictment with the evidence doctrine. They say only the presiding judge will contact the evidence before the trial after the indictment. They say that will be to prevent the prejudice of the other judge. And enhancing the function of the court in dismissing the insufficient prosecutory by the rulings. And also expanding the appointment of public defender or lawyer during the detention hearing in the investigation period. Also, we have enhancing the function of preliminary proceedings. There are also some proposals about to re-examine the cross-examination regulations in Taiwan, because we have always thought that we are a professional judge, so the cross-examination rules cannot be totally adopted by the American systems, because that's why the main purpose is not to misleading the jurors, but the career judge might not be misleading. But there was some discussion about that. Also, the decrease the obligation of the court, unifying the decision of the evidence rules in Supreme Court, because we have a huge Supreme Court scheme. So there were different opinions between of them. So it's very hard for us to use in the law for decided which part of the evidence rules should be used. And also enacting the sentencing procedures. We try to enacting a new procedure with independence from the trial procedure, just dealing with the sentencing factors. And now we are just trying to learning how to U.S. Judicial system to deal in these kind of things. And there's a most important part, that's the standard of transferring a different procedure, just like what I mentioned before, the speedy procedure and the ordinary trial procedures. That is all my presentations, and if you have any questions, I'm welcome to shoot me a mail or just ask me. Thank you.
Thank you. We'll now hear from Prosecutor Liu Shiguo. Thank you.
Good afternoon, everybody. I want to introduce. My topic is the conflict between civil law and the common law in Taiwan's criminal justice. Yes, the criminal justice system of the Republic of China on Taiwan is derived from the European continental law. it is including the authority of the prosecutor, the relationship between the prosecuting authority and the courts, and so on. So, briefly, Taiwan follows the civil law system of the Germany and Japan. It's our legal system originally. And over the past decades, Taiwan has introduced lots of elements of the common law system, especially from the United States, such as the hearsay rule and the implementation of the cross-examination. Why over the past decade, Taiwan has introduced such legal system from the United States? It may be because compared to the European country, we have closer relationship with the United States, not only in government, but also in academic. Lots of our professors and experts, they got their degree from the United States. When they come back to Taiwan, they introduce the element of common law system to Taiwan, such as, take it for example, our President Ma Ying-jeou and the former Vice President Lu Xiulian, both of them are the students of Professor Cohen. Oh, they are Jerry's students, so you know why it happened. Yeah. Oh, sorry. Yes. And what is the purpose of the cross-examination in Taiwan's criminal justice? My question is, who should we as prosecutor or being a defense attorney, you should to persuade in court? I think the judge is your answer. Of course, the judge is the answer. But why I ask this question? Let me clarify it. A, B, C, D, E is my answer. And it's a challenge of introducing common law element into Taiwan's continental civil law system. There are many differences between the civil law and the common law, especially in our system. The first of all is about the career judge and the prosecutor. In Taiwan, our judge and the prosecutor, all of judge and the prosecutor have to pass the national judicial exam and have to be professional training together for 2 years. Then you can choose to be a judge or to be a prosecutor. I think it's very different with the United States. So our judge is career judge. And secondly, we have no jury system. We have no jury system. So the judge is factor fighter, and who also apply laws and determine sentence. And the thirdly is the judge can. The thirdly is after the prosecutor file the indictment according to the code of criminal procedure, the prosecutor have to turn all evidence and the material and document to the court. So the judge can see all of the documents and evidence before the trial. So you see B and C. We have no jury system. Judge is the factor fighter. But in our legal system, the judge can see all of the document and evidence before the trial. And the fourth is the defendant is not allowed to testify as a witness in his or her case. In the United States, I think the cross-examination very effect in this system is very to testify. The witness to testify is very important in this system. But in our procedure, the witness is witness. The defendant is defendant. The defendant can't be a witness in his or her case, even he wants. No. So we can't to cross-examination the defendant to find the truth. And finally, the judge could ask any question to the witness after the cross-examination. It's according to our code of criminal procedure. So in our code of criminal procedure, we also have the rule of what is the direct examination, cross-examination, redirect examination, cross-examination. We have the rule and the order, but so what? After that, the judge can ask any question. Even the question maybe prosecutor or defense attorney had already object, and the judge said overrule or sustain. So anything, any question is about this case, judge can ask. So despite of this ABCDE, the law is law. So the prosecutor's office separate about 1/3 of the prosecutors to be the trial prosecutors right now. So we use 1/3 human resource to deal with the trial to appear in the court. And right now, the judicial yuan also have launched experiment of advisory jury, maybe lay judge system, or in Chinese we call it 官审制 advisory jury. You can see in the middle, three of middle, wear blue robe, three of them are judge, and the other one sit in the bench next to the judge is jurors. What is the advisory jury system? Right now it is an experiment. We test in 2 district court. The advisory jury, we have 5 jurors of the jury, 5 members of it. And the jurors are chosen by lottery. But of course, no professor at law and no prosecutor or no lawyer, no judge, even you ever been or anything. And only in felony case, so-called felony case in Taiwan is about the minimum punishment 7 years. And the jury, after the prosecutor and the defense attorney have concluded arguments, the jury will deliberate the case and render its advisory decision by themselves. I mean, only jurors, 5 of them, will vote, will decide what is their opinion. Only 5 of them. And their decision is not binding for the judge. Your opinion is your opinion. Judge's opinion is judge's opinion. But if judge disagree with their opinion, if judge disagree their opinion, he need to write an explanation. He needs to explain in his verdict, in his final verdict. Oh, okay. This is Taipei 101. Yeah. And my conclusion is I just point out the big difference between the civil law system and the criminal system in Taiwan's criminal justice. And I hope one day we will face it, but it seems not right now. Okay, thank you for your consideration. Thank you.
Now we're going to come to the external impact of Taiwan's progress. And we'll first hear from Professor Philip Alston, who has been very active in the UN as a special rapporteur. He has been the co-director, is the co-director of our Center for Human Rights and Global Justice, with which our U.S. Asia Law Institute happily shares the fifth floor of the Wilf building. And he's recently been in Taiwan as part of a imaginative, unique experiment of the Taiwan government. So, Philip, we look forward to your impressions.
Thanks, Jerry. Perhaps I'm the only person on the NYU faculty who has been to either Taiwan or China, thanks not primarily to you. So it's a great pleasure to speak at this conference. Jerry asked me during the coffee break if I needed interpretation, since English is American is my second language. I can't resist one comment, and this is simply a reaction by an Australian observer when Judge Liu mentioned that they ought to perhaps consider the American system of plea bargaining. I have to say, as an outside observer who reads American newspapers every day, I think of the American system of plea bargaining as a judicially sanctioned form of blackmail. And I'm quite serious. Nothing horrifies me more than the way in which that system operates, the untrammeled power given to American prosecutors to use whatever tricks they want in order to get pleas is extraordinary. So please don't go down that road. Okay, so on to the subject that I was supposed to talk about, just briefly. The experience of Taiwan's external review of its human rights performance. First of all, this is unique for obvious reasons, but it's something that international lawyers, a fairly odd breed, it has to be said, could actually get quite excited about. The idea that a country, to use a neutral term, which is not required to take on any international human rights obligations, decides to voluntarily do so, and then basically to try to mimic the consequences that would follow for a state that had ratified these treaties. It's a fascinating case study, in fact, but I won't go down that road. I think the most obvious question that must occur to anyone looking at this from outside is, why the hell would they do it? You speak to a lot of, I speak to a lot of government representatives, and they find the whole business of any form of external scrutiny to be rather excruciating. An imposition, something that they resent, and certainly not something that most of them would volunteer for. So why did Taiwan take it on? First of all, and I think I've no doubt Yujie will talk about this, but the contrast with China is obviously an incentive. Look, we are different. We have a greater openness. We are prepared to ratify the Civil and Political Rights Covenant, which China hasn't done. And President Ma basically intimated that at a press conference, which didn't make our lives any easier, because we had to insist that there was in fact no comparison, at least on the surface, which is true, because human rights bodies don't ever do comparisons. We don't go to Canada and say, congratulations, you guys are so much better than the Democratic Republic of the Congo. It just doesn't matter. The question is, Canada's got to be as good as it can be on its own terms. And the same applies to Taiwan and China. Secondly, I think the government of Taiwan wanted to get some sort of external imprimatur or blessing for the extent to which it has improved its human rights record. I think that's an important and quite a valid exercise. We also commonly see states engaging in this way in order to lock in the changes that they have made. Linked to that is often some sort of factional competition within a government. I don't know enough about Taiwan to know whether this is a factor in that situation, but it certainly is in a great many countries. In other words, by a faction, I mean you have a group of people who really want to commit to the rule of law, want to get some sort of external scrutiny, and they are opposed to another group which say, no, 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 we do things our way, the Taiwan way, and you can replace Taiwan with any other country. We do things the Australian way. We don't want foreigners telling us what to do. And it can be very useful in the context of that factional battle to get external actors in to strengthen the hands of those who want reform and to make it more difficult to wind the clock back. Finally, I think always relevant in the human rights area, and particularly it seems in the Taiwan case, is the influence of non-governmental organizations. Here, they seem to play a pretty crucial role in terms of planting the idea, in terms of promoting it with key actors in government, and then helping to really make it happen. The bottom line, of course, is that it really doesn't matter, actually, what the motivation was. Which of the above? The fact is it happened. And I want to say, I'll conclude in a moment by saying that I think it's actually very important, and I'm very impressed by the way in which it is moving so far. But before doing that, first of all, the question of how it was undertaken. This was impressive. I mean, I'm told that the relevant section of the prosecutor's office drew up some sort of list of experts that they would want to get involved in this. But as soon as I got an invitation saying, would you like to join this, I said, well, I'm not sure. Tell me who else has been invited, because that's absolutely critical. And I think most governments that were doing this would be very tempted to slip in a couple of lackeys, a couple of running dogs, if you like. But once one saw the name of Cohen on the list, professional troublemaker, and then a number of the others in the human rights community who were there, it was clear that this was an entirely objective list of individuals who would not be in any way withholding in their scrutiny. And so that was very impressive. Next, the community consultation dimension of it, very important. Extraordinary number of NGOs seem to be mobilized, rather well trained, in addition, I have to say, in how these processes should work. Over many years, I've seen a lot of NGOs in different countries who were far less familiar with the way in which international processes work. They had a general sense that if they come in and say that the government is a pack of fascists and they hate criminals or whatever, that's going to be very helpful. And of course, you have to say, well, that's interesting, but can you actually give me some information and let me make the assessment rather than just being abusive. But the Taiwanese NGOs were very focused on precise problems that they identified and the sorts of solutions they thought should be undertaken. Next, reporting by the state. The government reports were as informative, at least, as any that I've seen. A lot of government reports are pretty useless, to be honest, in the international system. I can't say that you get a huge insight even from the United States report, although it takes vast amounts of effort to produce it under the Civil and Political Rights Covenant. But there's not exactly a lot of confessing that is included in that reporting. Finally, in terms of the process, the group that came together ended up opting to remain reasonably faithful to what might be called the UN model. There was some discussion of this at a certain point. Some within the group said, well, why don't we have it much more open so we have the NGOs here, the government there, and they can sort of discuss it. Fortunately, at least I think fortunately, that model was not adopted. It's not the way it's done in the UN. And the reason is simply that that becomes problematic very quickly with bad feelings, bad blood being generated because you've got direct confrontational accusation. And while it might be considered to be a step forward in another world, I don't think we're ready for that, and I don't think Taiwan was the right place to do it. In terms of the recommendations, those of you who are interested will have read the recommendations, I think. If you haven't read the recommendations, read Yuzhe's report on the process, which is very informative. I think there are a number of recommendations that are significant. Very briefly, we recognize the important status given to these two treaties under Taiwan's domestic law, but it was also clear that the judiciary, which is true in most countries, it has to be said, almost all countries, has not yet adapted to the reality of the covenants being given this particular status and the possibility that they can then really make effective use of them. But it's a standard problem. My wife, who wouldn't want me to talk about her in this context, nonetheless I will, is Irish and has just done a study of exactly how the Irish courts look at the Charter of Fundamental Rights in that country. And it's the same story, basically. You know, the European Union Charter is supposed to be superior law. It's supposed to be binding in Ireland. The Irish judges have it at their fingertips if they want to do something with it. And what they're doing is quickly going, eek, I don't like this, I'll sort of leave it over there, and make the occasional reference to it rather than feeling empowered by it. We made the recommendation that there needs to be more judicial training. That's very banal. But what we did say is that it's not just ordinary training. What Taiwanese judges need is the opportunity to meet with other judges or other specialists in judicial behavior to be able to talk about how one can use an instrument like this without it really being problematic, because judges are naturally going to be worried about the impact of such a foreign object within their own domestic system. So a range of issues that, as I said, I'm not going to go into, but I think important statements on torture, important statements on prison conditions, which was a convenient way of actually saying something about the treatment of the former president, Chen. But in fact, the real issue, seen from a human rights perspective, is that those sort of conditions should not exist in the prison of a civilized country, and they should not exist in Taiwan. I think it was important to make that statement. So to wrap up, because I'm sure there'll be lots of discussion later on, the question of impact, what did it all amount to? I understand that Frank Upham threw a hand grenade in the earlier session when I was uptown talking to the World Bank about their great human rights policies. And warned of the illusions of procedure. And I think one could, if I can, I mean, Frank's talks are normally able to be reduced down to 3 words, and it sort of captures it all.
It's spoken more loudly with
more passion and... But I think that an outsider coming to this process could say, well, same problem, illusion of procedure. You know, the Taiwanese, very clever, they invite an external group in. The external group makes some recommendations, they go away. Taiwanese pay no attention really to it, saying, silly foreigners, now they're gone, we can get back to business as usual. That's, a legitimate expectation in this area. You'll excuse my cynicism, but it comes from being in the human rights field for too long, probably. But in fact, it's not at all how I see it. At one level, again, as Yujie pointed out, media reaction to our recommendations was very disappointing, very low key, didn't draw much attention. But the reality is that if you're really going to make a difference, progress has to be gradual. Revolutions don't work in this area. There's no point in coming in and saying, right, you've got to change all of these things, it's got to be immediate, it's got to be radical. What's much more important is setting institutions and procedures in place so that they can then make the gradual changes. Now, the empowering of the courts, nominally, it's been begun, and as I said, I think it can be developed over time, but again, in a gradual, carefully thought through way. Institutionalization, I am hopeful. I think it's very important that some sort of national human rights institution should be set up. I know there's the problem of where it fits within the overall constitutional structure, but I don't believe that is insurmountable. There's the idea, which I think has been announced now, of adopting a national action plan. All of these things set in gradual motion, reforms and initiatives which won't easily be rolled back, and which will give a sort of continuing impetus within Taiwan, regardless of external committees or groups in the future. And so I would conclude by saying that even though it's essentially a matter of procedural progress at this stage, I think that the seeds have been sown for a long-term continuing favorable evolution in the approach to human rights in Taiwan. Thank you.
Well, thank you. That was the kind of thoughtful and positive appreciation I had hoped we would hear from Professor Alston, and I also hope he'll take part in future periodic reviews of Taiwan's progress, because they do intend to have continuing review of that progress. Well, now we'll really listen to our final speaker here, Ms. Yujie Chen, who's managed the impossible. She got the Taiwan government, apparently, to put on this whole unique process so she could write her JSD dissertation about it. And she must be behind the scenes a very clever politician. She came to us in 2007 as an experienced Taiwan lawyer, got her LLM here, won the Bernstein Fellowship to work for human rights in China for a year. Then we asked her to join the U.S. Asia Law Institute, and now she is literally working on this very subject for her dissertation.
Thank you, Jerry. I have to claim first, I cannot take any credit for this whole process. I'm just a student in this area. And today, the topic that Jerry asked me to talk about is what can China learn from Taiwan about ratifying the ICCPR. And I think this is really a difficult question, because as you can see, obviously there are similarities. On the other hand, there are vast differences between the two systems. But I managed to come up with some reflections, and I'll share them with you. But I certainly hope that we will have a chance to hear more from the audience later in the Q&A session. So as some of you know, that China signed the ICCPR in 1998, and it's been 14 years, and it hasn't ratified it, and there hasn't been any solid indication that it's going to ratify the treaty very soon. So why has China been reluctant? And what does Beijing need to do in order to credibly ratify the ICCPR? And if for comparison purposes, obvious target for comparison is Taiwan, which just ratified the ICCPR in 2009. So what did Taiwan do to get the house in order before ratification? And what progress has it made after ratification? And is there any lesson that Beijing can draw from this experience of Taiwan? For China, there are many challenges to its ratifying the ICCPR. As you know, the treaty covers a wide range of rights that are not guaranteed in China's legal system or in reality. And some of them touch upon the very survival interests of the regime, such as the freedom to establish political parties. But Chinese legal scholars generally agree that many other issues are open to change in order to, in the words of the government, create conditions for ratification. So today I want to focus on our topic, more on criminal and quasi-criminal sanctions. What are the obstacles in these areas to Beijing's ratification of the ICCPR, and what can be changed? And generally, there are 5 areas that Chinese scholars usually will point you to when we talk about the challenges facing China's ratification. And we've talked about some of them. The first is re-education through labor, and second is protracted and often uncontrolled pretrial detention. Third is practice of coerced interrogations. The fourth is ineffective criminal defense. And the fifth is death penalty. So as previous speakers have already talked about the progress and challenges in these areas, I want to take a moment to sort of look at how Taiwan dealt with these 5 areas before ratifying the ICCPR. So the Republic of Taiwan, the Republic of China, that's definitely not a slip. Republic of China, Taiwan signed the treaty in 1967 when Chiang Kai-shek still ruled the island with his iron fist repression. But it did not ratify the treaty before being excluded from the United Nations in 1971. Since the martial law was lifted on the island in 1987, there has been tremendous progress in democracy and freedoms in the last generations. And one of the achievements is the establishment of a judiciary that's largely grown independent of political influence. And as previous speakers mentioned, the role of constitutional court, the Council of Grand Justice, in providing catalyst for so many important reforms. So in this context, one remarkable achievement is, as discussed by Professor Maggie Lewis, the gradual improvement of Taiwan's version of the re-education through labor, which led to its ultimate abolition in 2009. And the second area is pretrial detention, which has been subject to judicial review in Taiwan since 1997, also thanks to a Constitutional Court's groundbreaking decision. And so prosecutors nowadays no longer hold the power to detain people without court approval. Most of the defendants remain free pending trial. So since 1998, out of 100 defendants prosecuted in Taiwan, roughly only 3 to 5 defendants are held in pretrial detention. The third issue is coerced interrogations, which were indeed a serious problem in Taiwan during and before the 1990s. But nowadays, such allegations are considered the exception rather than the norm, thanks to increasing awareness of the connection between wrongful convictions and coerced confessions. And also the judiciary has played an important role in checking police misconduct. Fourth, in the area of criminal defense, we have witnessed some improvements, including the lawyer's right to be present during interrogations, their right to meet with the client prior to the first prosecutorial or police interrogation, and the protection of the confidentiality of the client-lawyer meeting. Finally, on death penalty issues, unfortunately, Taiwan has resumed executions since 2010 after a 4-year moratorium, and there's just no sign that under the current administration, death penalty is going to be abolished anytime soon. But several reform proposals are under discussion. Some of them are stimulated by ratification of the ICCPR. So given the above sort of recap of Taiwan's progress, what can China learn from this experience? First, I want to sort of put out a disclaimer too. I'm not here to sort of put on the gloss over Taiwan's progress. It's not a sweet talk about what Taiwan has achieved. I do recognize there are still many problems, but indeed there has been little recognition of what Taiwan has done compared to the world attention to China. So the point here is indeed to say that before ratifying the ICCPR in 2009, Taiwan had improved many areas that China is now concerned about when considering ratification. And one positive way to look at this is that China has been reluctant to ratify the ICCPR because it is taking this commitment very seriously. It indeed wants to implement the treaty, so it wants to create the conditions for ratification. And so put in this context, we look at Taiwan, the scope of Taiwan, the scope of change required by the treaty in Taiwan has been quite manageable compared to China's current conditions. China's concerns are generally understandable. On the other hand, no state, I think it is very clear that states should not wait until their conditions become perfect before they can ratify the human rights treaties. And in Taiwan's experience, we see actually there were a lot of issues that can be improved because of the ratification. Just look at the 17-page concluding observations produced by Professor Alston, Professor Cohen, and other 8 experts. And you see, actually, there are a lot of aspects that are far from perfect in Taiwan. So there's indeed a process that is about to be stimulated by ratification. And this process may be slow in the eyes of many activists in Taiwan, but I think it is likely to be sustainable now that the treaty has been incorporated into Taiwan's legal system. And more importantly, the civil society and the legal professions work very hard to use human rights treaties to persuade the government, to hold the government accountable. And they use the treaties to enrich their thinking and their discourse in their lobbying and litigation, and also to unite efforts from various civic groups to put pressure on the government. So to conclude my remarks, I don't think Chinese leaders would be would very much appreciate the autonomy and vibrancy of the civil society in Taiwan that we're seeing right now because of ratification. But I think it is in the interest of the Chinese government to use ratification to generate momentum for consistent progress that is so much needed in China's society nowadays, which is confronted with vast social problems because of China's rapid development. And instead of repressing long simmering complaints from the society until they erupt, I think a more productive approach for Beijing would be to use ratification to channel the demands of the public by the kind of systematic and steady progress that we are witnessing in today's Taiwan. Thank you.
Very good. Well, you've just been witness to an amazing phenomenon. It's common in academic life in America for speakers to say they really want to hear from the audience. But it's not common for the speakers actually to give the audience time to express themselves. And thanks to the revolutionary self-discipline of this gang of five, we have a full half hour to review not only questions we never got to this morning, but questions that were now stimulated by these very nice presentations this afternoon. Now, one thing about the Taiwan exercise that strikes me, the communists in the early decades of their rule after 1949 used to emphasize, as I said earlier, not only thought reform and trying to create the new so-called socialist man through re-education, either criminal or non-criminal, supposedly, but we now see, we no longer hear about criticism and self-criticism. In the early decades, there was so much emphasis. The way to progress is piping, 自我批评, self-criticism. You just don't hear that. But what Taiwan is just doing now is precisely that. They are arranging institutions for absorbing criticism and promoting their own self-criticism in order to implement human rights. And that's really quite a startling phenomenon that we should not overlook. And I was struck by listening to these very good presentations, how accurate they seem in terms of characterizing what's taken place in the last 25 years in Taiwan, except in one thing. We talk about the shift from the continental European process to the Anglo-American. It's not complete, it's sort of mixture. But I want to ask our people from Taiwan, what about the German influence? It strikes me in Taiwan legal education, in Taiwan legal implementation and practice, in Taiwan appointments to the judiciary, the German influence is still there. I was stunned when my former student, a very brilliant Ma Ying-zhou, came to appoint recent members of the Constitutional Court. He appointed no fewer than 4 who had studied in Germany. So how does that fit in with the portrait we've heard now? What about the German influence? Who wants to take a shot at that?
Sure. I think, actually speaking, the German influence is still existing in Taiwan a lot, especially in criminal law. But the criminal procedure law, just like I mentioned about, we combine the German system and the U.S. Anglo system together. So that may rise in some questions, such as I'll be assigned to research to a sentencing guideline in the United States. But you know, in German criminal law, they have a very complicated in calculating how to make an account of criminal offenders. But it is hard to combine this together if we adopting the sentencing guideline of the United States. So because most of the professors are also from studied from German, they didn't charge their tuitions, I think. No, but I don't think that's the main reason. But yeah, and also we have some professors who study from Japan because we have a very close relationship with Japan. So we can
But
find.
that's also the German influence in
Yes.
Japan.
Yeah.
Yeah. I'm struck. I don't know. I'd like to hear from people from the mainland. Is there a strong German influence in legal education today? I don't sense that in mainland China, but Professor E?
Yes, I think it depends on which field you are concerned. Because I think it is the same with Taiwan, because we have many scholars from Germany, from Japanese, from Japan, whose major field is criminal law, substantive criminal law. But I think in the field of criminal procedure and evidence, we are mainly influenced by Anglo-American legal system.
That's
So-
my impression, that by allowing so many scholars from China to come here, that the Communist Party has created more problems for itself because they come back and they teach hundreds of thousands of graduates that essentially American or Anglo-American, Australian criminal procedure. And is that subversive? Does it undermine the underpinnings of their government and society? It's interesting, this whole question of where people go abroad to study and what they bring home. I know the year I lived in Japan, I was struck looking at the foreign ministry of Japan. It was divided into the German school, the French school, and the Anglo-American school. And it raised questions, what about the judiciary system? It's interesting. The only other question I had, you want to comment on that? Oh, Ira?
I had another question.
Oh, I was going to say the only other question I had is this relevance of democracy to law reform. All over East Asia, even in China, we've seen evidence of the desire to make court adjudication more democratic. And that's why Taiwan has this interesting experiment in the merely advisory jury. That's why South Korea has done it. Japan, however, has gone to the French model, where you have a collective decision by laymen and judges in important criminal cases, and it seems to be taking. It's another way of getting popular participation for ideological democratic reasons. Ira?
Well, I mean, first of all, I just want to say the panel presentations were all fantastic, and I learned a lot from this afternoon's discussion. My question goes to the relevance of Taiwan's legal reform for China. As Maggie said, a few other people said, when we've gone to China with programs and we bring experts from Taiwan, it certainly seems that when the Taiwanese experts talk about their experience, our Chinese audience perks up a little bit more, especially when you have a good speaker like Professor Wang Zhaopeng, who came last time, and can say, 20 years ago, we really weren't so different from you, but we've undergone a lot of reforms. But as I listen to the panel and hear about, I mean, we certainly all know about multi-party democracy in Taiwan. We know about a free media. We learned about the Constitutional Court as well as the Supreme Court. And Taiwan already seems to have so many institutions of, for lack of a better word, liberal democracy in place. Is Taiwan's example really relevant for China? Can Taiwan's example really help bring about meaningful legal reform in China?
And of course, you could say that in spades about the United States as a model for Taiwan. It's so different. Is it relevant? Is it helpful? Or is it troublemaking? Judge Marty Marcus.
I'm intrigued by this notion of an experiment with an advisory jury. And my question really goes to how you judge the success of an advisory jury. Does it, which goes to the what is the purpose of a jury? You know, do you judge it? Is it a successful experiment if the jury and the judges agree often, or is it a success if they don't agree? How do you judge which is the more accurate verdict? Or is it just having public participation in the process of reaching a verdict that is the goal?
Yeah.
Use the mic.
I think the main purpose is to expand the participation of the public opinions. And because it's just a draft, so they just not really having the jury trial in Taiwan. So I think we are trying to design a system which can make the people to get more realized about how the judicial functions works. Because we are facing some serious problems which are being criticized by the mass media that say the judges are reacting so slowly. They're describing us as a dinosaur judge. It's very, yeah, so the way we are thinking about to solve this problem is to take in some jury system to make them participate in this kind of progress. And also I have to mention about that it's kind of tend to make limited the discretion of the judge in East Asia. I don't know the reason why, but through my conversation with the Korean judge and also to the Japanese judge, it seems as a trend they are all trying to limit the power of the judge and to expanding the participation of the citizens. And I also have some questions about the stating about the juries, what the experience in United States, and also how to give the instruction to the juries. Sorry, I should answer the question, but I always want to realize about this. So I don't know. I have already answered all of your questions. So
Jerry,
We hope you'll have a chance to visit your court. We're getting increasing requests for that. Yvonne Chan?
Jerry, could we respond to some
sorry.
of the questions been raised so far? So, well, first of all, with Ira's question, which is, I think we're avoiding because it's a very hard question. Is it helpful to bring in the Taiwan experience or the U.S. experience, or is it troublemaking? I guess it's from whose perspective you're looking at, because it could be helpful and troublemaking. But I think, and we've had this conversation, there are some areas, discrete areas of law where I think it is helpful to bring in both the U.S. and the Taiwan experience. We've talked a little bit about plea bargaining. And in Taiwan and the mainland, you have, if not plea bargaining, that doesn't translate well directly. So they have simplified procedures, summary procedures, but some form of trial condensing or trial avoiding procedure. I think that's inevitable in any system. And there is no way when Taiwan went to this reformed adversarial system that you could have a full-on trial for every criminal defendant. Not going to happen. So with that in mind, I think that then, even teaching from a negative example about, how the U.S. has run into problems, or, in the mainland today with this dealing with more technical investigations. How can police broaden the types of evidence they're using beyond confessions, which are cheap but not necessarily reliable, and to use more sophisticated techniques for evidence collection. And part of that, too, is issues like undercover policing. The United States embraces that in a way that a lot of countries are uncomfortable, including Taiwan, which, correct me if I'm wrong, but I understand there's been a draft law that is kicked around about undercover policing, but it hasn't passed because of concerns about that. So I do what abuses that might bring. So I think there are ways that the experience can be helpful. But the big question is how much can the mainland China's criminal justice reform happen with the existing political structure? And I personally increasingly think limited. I mean, I don't think we're going to see massive change unless we also see a loosening up in the government towards other sort of freedoms of expression and assembly. But there is room to change. And as far as the advisory jury question goes, when Jerry and I were in Taiwan about a year and a half ago, there was a lot of criticisms about this advisory jury, that it was just a big old PR move by the judicial yuan, the judicial branch, to say, look, we're involving the public. But in reality, are these just going to be bumps on the bench that aren't going to do much, because they can advise the judges, but they have no control to actually bind the judges. They don't have a real vote. So there's a robust debate going on in Taiwan whether this is window dressing or this is really bringing the voice of the people. And so far it's only been these two experiments, and I think it's going to be interesting to see whether that takes hold in a larger way.
Of course, that's been going on in the mainland for a long time. They brought in from the Soviet Union the Peishantuan, the people's assessors, and of course most people realize people's assessors don't play much of a role, although now there's another attempt to make them more effective. But in some areas of China, as some of you know, Henan province especially, there has been an attempt to introduce the so-called jury trial, using the Chinese term for translating American jury trial, Peishantuan. But of course, as far as we can tell, this has got no real resemblance to our own jury trial, but there is supposedly a consultation of the people who happen to be in the courtroom about what should be done before a decision is made. But of course, the party determines who's in the courtroom. So there is a kind of, you might say, jury selection process of a novel nature. Yvonne Chan. Let's hear from Yvonne Chan. But you got to speak up, Yvonne.
Yeah, a couple of comments. Obviously, sort of like international norms take a while to
I
take.
can't hear you.
That's because you're deaf in one ear.
My hearing
right.
aids aren't working.
Right. International norms take a while to take root in a country where the institutions aren't there and they don't have the liberal democratic systems on which a lot of the Anglo-American principles have evolved. So in terms of legal education in Taiwan now, to what extent is there the development of encouraging law students to understand these principles, to see how they can be translated within the domestic legal system? Because unless you do that, and unless you strengthen local institutions, in practice, it's going to take an incredibly long time before you have this awareness amongst all actors in the criminal justice system of these rights. And the second question really is the legal profession. You talk about a 10% pass rate of the bar. So what is it in the legal profession? Is it really a monopoly that really is just focused on making money? Because my perception, being in big law, is that people are going into law not because they want to do criminal justice. Very few people want to do public interest law. They want to make the big bucks. They're coming to America to do their LLMs, and they want to work in big law firms and make a lot of money because they see that economic law is really a way to make a profession to get rich. So what is it that you can do within the legal profession to inculcate sort of like it is a profession that is worth doing, and also to get involved in the criminal side and not just earning lots of money on the economic side?
Yvonne Chan is an American lawyer from New Zealand, trained in New Zealand, who studied law also in China and has worked as a lawyer in Beijing and Hong Kong, as well as now in New York. And she knows a great deal about the realities of negotiating contracts, settling disputes with China. Yujia, would you answer that question? I wouldn't mind if you even restated it.
So first on the legal education, to what extent does Taiwan sort of inject this knowledge about international norms into the legal education system? I have to say there's really not much progress in this respect, and I think it takes longer periods of time than other reforms, institutional reforms in the legal system. I think education is now slow to pick up this trend of the sort of learning of international norms. As you know, Taiwan has been excluded from the United Nations since 1971, and there was indeed a wave of students coming to the United States to learn about international law, in particular international public law, in the 1970s. But once Taiwan is out, then you sort of see people there are not very much interested in this area. But I've also seen efforts by the Judicial Yuan in trying to inject this curriculum in the training institute for judges and prosecutors, hoping then they will find these international norms useful in their work. So that's an area that we really need to work on. In terms of legal profession, I don't think we have done enough. When I came here in the United States in 2007, I was very impressed by the public interest clinics here at NYU. And compared to what I had in Taiwan at the Zhenji University and at the graduate school, it was just sort of mind-boggling for me to see there's indeed a whole public interest world that legal professionals can pursue after graduation. So,
just a quick response to the Professor Margaret's questions. I don't think that adopting the late jury system is just a window dress of the Taiwan system, because if they just the prosecutor, they'll say that if the judge have a different opinion with the jury, with the late jury, they have to write the reason. I think the humility that will be force the judge to follow. I predict most of the judge will follow the opinion of the late judge. And by the way, there also as a question, maybe the late judge can let disclosure. How do they discussing about the opinion to the media? That might be cause some pressure to the practice of this kind of system.
Do they do that?
Not yet, because it's just a draft. But I also
haven't started.
Yeah, they haven't started. But I also was pointing out the most criticized of these systems from prosecutor was studied in United States. They say that the jury system in the United States have some problems. Okay, and the other criticized, as you say, that why don't we just totally adopt the jury system, not take this kind of lay jury without no binding opinions? And that's why I have to point it out that the Judicial Yuan pointed to court to trying to adopt these systems. Because this is a mandatory, that means the defendant cannot choose to use the bench trial. I think it might be cause some constitutional issues about equal protection. Those who didn't use this system, or those who the defendant used this system, they can argue why they cannot stake in the different procedures to proceed in the trial. That's my opinion. So for supplement, thank you.
Mr. Guo?
I think the Professor Yu's opinion is just like in the Taiwan prosecutor's opinion and the lawyer's opinion. The agreement in this issue. Finally, only Judicial Yuan insists to do this such change. The prosecutor and the lawyer, they choose reject to this experiment.
I think one thing worth emphasizing is over the last couple of decades, the power of the prosecutor, who used to be king in Taiwan's criminal justice, has been significantly eroded and shifted to the courts. And that's a very important development in many respects. And it's impressive to see that in practice in Taiwan. Professor Julian Koo from Hofstra.
Thanks. I really enjoyed this conversation too. I wanted to just touch on the big question behind, I think, all the discussions about Taiwan's reforms, which is, causation. Right? So, what are the proximate causes for the legal reforms that were described so eloquently by everyone on the panel? And was it law? Like, did law itself drive the reforms? In other words, or was it political reform, as Maggie suggested? Which raises a question that Professor Uppman, in his very sort of sparkling earlier presentation, which everyone keeps referring to, is about, is it an external influence, in this case, say international law, was that, it's unlikely in Taiwan, but was that part of what was driving legal reform? Or is it, as I'm more inclined to this view, that domestic constitutional norms were the driving force? If law was a driving force at all, at least in Taiwan, it strikes me the history suggests that constitutional norms were perhaps more influential in driving legal reform than international legal norms, I think, for Taiwan. And I guess this is a question about whether we think external legal norms, like international legal norms, could have an important role in driving a domestic legal reform or domestic political reform in China. I mean, the Taiwan case study strikes me as not supportive of that view, that the external pressures of international legal norms was not part of this. It was more likely part of domestic constitutional reforms, if at all.
Well, Yu Jie Chun is sure to have one reader for her dissertation.
Well, so causation is always a difficult question in case studies. I agree that in Taiwan's case, as you can see, it's being largely isolated from the international society, and therefore the development of international norms hasn't been very effective in Taiwan in terms of trying to improve the legal system. So the legal system largely developed before ratification, largely developed through many institutional changes that we just talked about. But I do have some hopes for this introduction of international norms. For one, if we compare it to constitutional development, constitutional norms, for Taiwanese judges and prosecutors, they cannot do the constitutional review in their cases. So I think one advantage of introducing these international human rights norms is that they can now start using these the content of the treaties that actually is quite similar to some of the rights provided in the Constitution. And they don't have to suspend the court proceedings and file their application to the Constitutional Court. They can now actually use those articles in the ICCPR and ICSCR. So I think there's still an advantage of using that aspect, and maybe they will pick up very soon.
Jerry, can I add something to that?
My own impression watching Taiwan over 50 years is, first, there is an intrinsic, fierce, intense belief in maximizing legal protections against the return of anything similar to the terrible dictatorship they suffered for 40 years of martial law. Second, this has a fierce political aspect. the opposition party wants to use this as a political club to gain or regain power, and the Kuomintang has to compete. And that's, so internal politics is pushing. But the other motive is Taiwan knows it's in a contest for world opinion, especially American opinion. If someday the question comes, will America go to the defense of Taiwan? What we believe about the value of what's taking place on the island will be a critical factor. Americans are very ideological, as you know. And if Taiwan shows it has gone to unusual extent to develop human rights, that makes it more likely a president could get support for intervention in any battle with the mainland. So there are many reasons, I think, but those are three I think are salient.
Sure.
Maggie?
Yeah, I just want to add a few things. And not just looking at the recent incorporation of the ICCPR, but if you look back in Taiwan's history to when martial law was first going away, and you've got the KMT and the DPP, the Democratic Progressive Party, which started as this Dangwai, this entity outside of the KMT, and the people who were so core in the DPP, and people like Lu Xiulian and Annette Lu, not only were they lawyers, foreign-trained lawyers, but they individually experienced repression. You know, they were locked up. They tried to stand up for these rights, and they ended up in jail. So it's very personal, I think, as far as, you know, wanting these rights to be taken seriously by people who, not that long ago in Taiwan's history, very personally remember what it was like when those rights were not there. But it is interesting that you didn't have the sort of foreign assistance training. You didn't have the USAID money in the same way, or the Ford Foundation money in the same way, or all these, you know, big NGOs and sort of the law and development way going into Taiwan. But the more time I spend in Taiwan, the more I see how important it was that people studied abroad. I so much, when we talk about the German camp and the U.S. camp, and okay, where'd you get your JSD? Where'd you get your LLM? And that power and that influence early in their careers, I think has been very important to how Taiwan has developed.
And just to make a supplement, accepting to the competition of the two parties' policies, I think the education and also the competition of mass media also creating the surroundings, to force the government to making the reform of criminal justice. And also some mistrial cases, I have to admit it, that will also improving us, to push us to making some improvement. And I also want to say that we want more supervision from the international societies. That will make us to know what the standards of international society. Just like Professor Austin mentioned about, we also think that the jails, the too crowded jail was a very serious problem too. So this can make us forced to make small reforms. Yeah, that's my supplement.
Just to briefly pick up on Maggie's point, these two international human rights treaties, the ICCPR and ICSCR, were actually initiated by Chen Shui-bian's government when he took power in 2000. And the motivation that I find was to use this as to highlight its difference from the KMT government. The KMT government never had a consistent human rights policy before 2000, and when the 2000 presidential election went to Chen Shui-bian, it's time for the DPP to really make a case about the party's character and his own personality. Or highlighting his own personal experience. So I think there's indeed a political competition that push the institutional changes on this island. And a human rights scholar that I interview aptly puts it, he said that both governments, that both parties are have been engaging in human rights competition.
One of the intriguing questions of history involves one of the two leading human rights advocates among the NGOs in Taiwan, a man we know as Peter Huang. When he was, in effect, a refugee from the Kuomintang in this country, tried to assassinate the son of Chiang Kai-shek in the Waldorf Astoria Hotel. He failed, fortunately. If he had not failed, it would have been really interesting because it might have had just the effect he didn't want. Although the son of Chiang Kai-shek was a notorious killer, when he headed the secret police when I first went to Taiwan, by the mid-'80s, he, unlike Deng Xiaoping, saw the need in his old age to start institutional reforms of a political nature that started Taiwan's democratic, peaceful, gradual revolution. Deng was brilliant when it came to international relations, the return of Hong Kong, how to deal with Diaoyutai Senkaku dispute. He was great for economic development. But to his dying day, he remained a Stalinist. Whereas this fellow, Jiang Jingguo, the son of Chiang Kai-shek, is remarkable. Most of us get increasingly conservative, if not reactionary, as we get older. He became more liberal in his last few years. And to my surprise, I found myself saying nice things about him when the press told me he had died. So it's interesting. If that human rights activist had succeeded, if he had been a better shot, one doesn't know what would have happened to history. Well, I want to thank our speakers. I think it was a terrific panel, and I thank the audience for adding to the interest here. And I'm very happy we did this program. Thank you.